Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, are your hosts. They are managing partners at Whitaker and Hamer Law Firm, offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, Gastonia, and now in Morehead City. Our special guests in studio, Cassandra Nicholas and Taylor Scruggs-Smith, also attorneys at Whitaker and Hamer. Joe Hamer is on assignment this week, and I understand because he's the boss, he can change direction on the show, and that's going to happen right now. Josh, where are we going?
Well, I want to make sure we have enough time to answer our listener question because like I said, we have Taylor with us. Taylor is one of our family law attorneys, and anytime we have her with us, it's a good time to tackle all the family law listener questions that build up when she's not here. So, again, these are real questions that we get from real clients, and what I do is sometimes I combine these questions, but I kind of turn them into general questions. And so my question today is why do people get prenuptial agreements? All right. Why do people get prenuptial agreements, and what can you handle and not handle with a prenuptial agreement? All right. So we're talking about prenups. All my boys, when they get old enough, they're going to have prenups because their father's an attorney, and that's how we're going to roll.
Josh, do you have a prenup?
I don't. I'm all talk. The boys will have prenups. I do not. Luckily, when I married my wife, I owned nothing. I had nothing of value, and she didn't either, so it worked out.
Okay.
But Taylor, tell us what a prenuptial agreement is.
Okay, so prenuptial agreements, we hear about these a lot for celebrities and their assets, but everyday people can get them often. It's just an agreement saying, in a sense, I'm coming into the marriage with this, and no matter what happens to this relationship, if we decide to divorce, that stays mine. So you're kind of setting a line early about what stays yours, what stays your future spouse, and how you guys are going to split things going forward, because there's always language in there about, okay, well, if you make something joint, this is how it gets split, things like that. So it's a way of protection. We often see them when people have kind of already gone through a divorce and they don't ever want to have to worry about splitting assets like that again, or they've heard the war stories.
Is it a pretty flexible agreement? Like, how much can you build into there? I know with celebrity ones, I've seen examples of like formulas, like if you stay together X amount of years, then you get X dollar amount, stuff like that.
So you can go that detailed in a prenuptial agreement and kind of go into, all right, let's say somebody becomes a stay-at-home parent. This is how much support they'll get if we separate after that. You can get that detailed. I've even seen clauses put in about, if somebody cheats or we end the marriage because of drugs or alcohol or anything like that, this is what's going to happen. It's kind of like morality clauses. You can go that detailed. The main thing I always have to warn clients about is you can't really put anything in a prenup in North Carolina anyway. You can't put anything in a prenup that has to deal with child custody or child support. The court is like, you can decide whatever you want between yourselves, but you can't make those decisions early on about a kid. It's considered against public policy, and almost every CLE I've done, every family law attorney I talked to in law school, they were like, even if it's not explicitly mentioned, never put kids into a prenup.
So I see these a lot in my area of practice. I deal a lot with real estate business law. So we'll have, two spouses who are already older, right? Have already been professionals, have already acquired real estate, have already acquired things. And going in this marriage, they kind of want to continue to handle those kind of things separately, keep them separate. They don't want them becoming marital property. They don't want a spouse to get a marital interest in something they've already spent 30, 40, 50 years acquiring. And so I see a lot of simple ones where like, look, this is what I got. This is what you got. It's going to stay our personal. If we want to make something joint, we'll do it.
Right.
But everything else, and then that can be combined. I think we've talked about a free trader agreement. Sometimes these prenuptial agreements
just have that free trader language kind of built into it.
Right. So in North Carolina, there's a statute that allows you to be a free trader. And basically that's to be a married person who kind of operates individually. Right. Because if you do what me and my wife did, you just go get married, then you didn't have anything before, you get everything afterwards, then your spouse, it doesn't matter who owns it. The other spouse is going to have a marital interest in it. It's going to be presumed to be marital property. There's exceptions, and what have you, but that's just kind of the general rule. But if you have this prenup, then you could continue to acquire property separately. You can buy and sell property without a spouse joining in. But like you said, Taylor, there are some things you can't. There's a lot of stuff you can agree to. Like Cassandra said, you get very specific about post-separation support, alimony. You can make things fault-based, like you were talking about, right?
Right, and that's a big thing because North Carolina in general is not a fault state. When it comes to divorces, North Carolina is a no-fault state. So if you want to say if you cheat, all these things happen, usually it has to be in a prenup.
Right.
But child custody and child support can't be. Court does not want you deciding how custody will be split early on. They don't want you limiting child support early on. North Carolina is very particular about, especially child support. They have North Carolina child support guidelines, which is a calculation that the legislator came up with to figure out how much support should be given to a child based off the parent's income and who's mainly keeping the child. Courts are always a big thing when it comes to children, that they should have the benefit of both parents and the income coming from both parents. And so
if it made its way into a prenup and then the couple gets divorced, the court would just invalidate that portion. Have you seen courts invalidate other things in prenups other than dealing with kids? Like just based on like if a fairness, like if it's just leaving one spouse destitute?
So actually, North Carolina came up with a statute that says even if you're in a prenup waiving your right to spousal support, if you would have to get on state assistance because of the divorce, the other spouse has to pay you some type of spousal support until you would be off state assistance. They can't leave you broke and going off of state assistance or on welfare or something like that just because of the divorce. So even if you're waiving your right to alimony and the other spouse is waiving their right to give you alimony, doesn't matter if you're going to have to go on state assistance after the divorce.
And prenuptial contracts are like agreements are like any other contract, right? So you're subject to all the normal requirements of a contract. There has to be some sort of consideration, I guess, entering the marriage. You got to be on equal footing too, And so I think if you agreed, you have your own attorney review. I think if you agreed that if I entered one and I agreed if my wife left me, I didn't have to get any support or anything like that, and I was left, to have to pursue food stamps or whatever. You can argue that I didn't understand what I was signing, right? Maybe there's some consideration issues. There's some things that can...
Voluntariness is a big thing when it comes to those type of marital agreements in North Carolina. So they always got to be signed and notarized. And if they can show it's not voluntary, like you didn't understand what you were signing or you were forced into it.
Yeah. And even if you're on equal footing at the time you sign, marriages are sometimes long and
hopefully
and circumstances can change where someone was on equal footing when they signed but then lose their job, income, get sick. So
right.
I'm glad there's that kind of safety net.
Yeah, there's that safety net, definitely. And then courts have gotten very particular about when somebody gets the prenup. Like it's okay if you get it like before the wedding, but like you can't tell somebody like they have to sign in that moment. You got to watch when you're giving it to them, how much time they had.
All right. Well, we are up against the break. We will take that. This is the Outlaw Lawyers, Josh Whitaker and Joe Hamer, your host, managing partners, Whitaker and Hamer Law Firm. Again, practicing attorneys here in North Carolina, and in studio this week, Cassandra Nicholas and Taylor Scruggs-Smith, also attorneys at Whitaker and Hamer. If you've got a legal situation you're facing and you've got questions, call this number, 800-659-1186. That's 800-659-1186. You can leave your contact info, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the Outlaw Lawyer, questions@theoutlawlawyer.com. Back after this.